that is of course part of the case. But the conduct about which we complain is an ongoing one. It is the continued use of Mkhonto Sizwe from now until, and into the future. So it's not correct that the matter has become moot or because the 2024 elections have occurred. It's also not correct that our case was limited to the 2024 elections. It is a case based on a continuing wrong, which we say it merits the attention of an appeal court.
So the point is made by the respondents that the basis on which the leave to appeal is sought differs from the case which the applicant has made out in its founding affidavit. What do you say to that, Mr. Mayor?
My Lord, that's exactly why I'm pointing you to those paragraphs, because in those paragraphs, which is, and similarly for trademark infringement, my Lord, paragraphs 83 to 89.
But the question that I'm asking
I appreciate that,
is,
Lord,
where does it appear in these paragraphs, from paragraph 83 onwards, that the concern of the applicant is not limited to the 2024 elections, but
let us read.
well, I haven't finished yet, Mr. Mayor. But is there a continuing wrong that needs to be arrested?
Well, my Lord, with respect, that is a self-evident proposition, because for so long as the mark is continuing to be used, there is continuing harm. Trademark infringement doesn't go away just because the election is passed. And paragraph 87, I have demonstrated that the ANC's Mkhonto Sizwe is well known in South Africa and indeed globally. The first respondent, that's the MK Party, has gone to some lengths to create a non-existent association between the ANC's Mkhonto Sizwe and itself. To this end, the first respondent's apparent most vocal supporter and apparent member of the ANC has drawn some non-existent association between the ANC and the first respondent. None of that, my Lord, is limited to the 2020. In fact, it's got nothing really to do with the 2024 election. It's about the continued association between the MK Party and the ANC and its history. 88, the former president is reported to have said a vote for the first respondent is to rescue the ANC from the outside. I hasten to add that at this gathering, the infringing logo of the first respondent was on full display. In fact, when he uttered the words, the former president was clad with a t-shirt fully displaying the infringing trademark. So those are examples of conduct that will continue into the future. 89, it is clear from the above utterances that the use of the first respondent's mark is likely to take unfair advantage of or be detrimental to the distinctive character or repute of the ANC's well-known trademark. Those are all allegations which apply, which continue to apply today. The same is true, I don't want to read it all, of paragraphs 103 to 109, all of which relates to the sorts of examples, they include examples of use of the Mkhonto Sizwe mark, which are not going to stop simply because the election has come and gone.
Yeah.
On the question of jurisdiction, my Lord, Your Lordship made, certainly as far as we are aware, it is the first time, my Lord, that a High Court has found that it does not have the jurisdiction to determine a trademark infringement in passing off case. That has never happened before, and with respect, on that basis alone, we submit there is at least a reasonable prospect that another court may differ with you on that
Yes, but
subject.
Mr. Merit, aren't you being selective or taking it out of its context? The context in which that finding was made was in the context that this was an election matter that fell within the purview of the electoral court.
Yes, my lord. Well, that was your
And
lordship's
then
finding, yes.
effectively, what you would have been asking me to do was to split the matter to find that certain parts belonged in the electoral court, and then on the same papers that this court had jurisdiction to deal with the trademark aspects.
No, my lord. That is how you saw it, yes, my lord. But we were never asking for it. We never. You will recall, my lord, that I argued strenuously that this is not an electoral matter.
Yes.
Yes. So, my lord, we weren't asking for the same relief on the same papers. We didn't contend that this was an electoral matter. We maintained from the outset that this was an intellectual property matter.
Yes. If you fail at hurdle, that if you don't get past the hurdle that this was a matter that belonged in the electoral court, then the rest of the debate becomes academic, not so.
That is so.
Yes.
But with respect, my lord, we we differ strongly, my lord. I don't want to put it any higher than that. My lord, it's no different. The essence of your lordship's finding was that because the ANC had raised this issue of the trademark infringement in those electoral court papers, it was on some basis prevented from now bringing a trademark infringement case in the High Court, or passing off case in the High Court. My lord, we differ for a number of reasons. But firstly, my lord, the fact that the ANC raised those objections in that forum does not serve to vest that forum with jurisdiction to determine the trademark infringement in passing off. It actually happens quite frequently that, for example, somebody raises a competition law issue in a High Court, and actually the High Court says, no, you're in the wrong place, you need to go to the Competition Tribunal. The fact that you raised it in the High Court does not prevent you going to the Competition Tribunal. So your lordship is correct, it was raised. But the fact that it was raised in that forum is not a basis upon which to deny the ANC's right to approach this court for relief. The second point, my lord, is that where we submit respectfully that your lordship erred, is that once your lordship found that the High Court does have jurisdiction to determine trademark infringement and passing off cases, then it is required to consider it.
Yes, I'm with you that the High Court, in terms of the proper interpretation, has jurisdiction to determine the trademark infringement. What I'm trying to ascertain from you in the context of the appeal is practically how would that have applied in the context of this case if I maintained that the electoral court was the appropriate forum for the resolution of the matter?
Well, my lord,
that would be the end of it.
With the appropriate forum, you would, no, my lord, with respect, you can't, with respect, deny or refuse to exercise your jurisdiction, which you admit you have, simply because you think it would be better placed elsewhere. Once your lordship accepts that you have jurisdiction to determine, you are required to exercise it. The only basis on which you could not have done so was res judicata, and there is no suggestion of that here. So, and my lord, this is not, although this was the first time this arose in the electoral context, it is not, as we've pointed out in the heads that we filed, it does happen, my lord. This regulatory, this interaction between regulatory and high court matters does happen. So, for example, there are cases in which pharmaceutical products have been approved by the Medicines Control Council, including on the basis of whether their names are confusingly similar to other pharmaceuticals on the market. And the Supreme Court of Appeal said that is entirely irrelevant. They decide trademark infringement in passing off cases, and the same we submit it ought to have applied here. The fact of the matter is, my lord, that neither the IEC nor the Electoral Court can make findings on questions of trademark infringement and passing off. They have no regard to what is on the trademarks register. They have no regard to common law rights. They consider, and this is clear from page 8 of your Lordship's judgment, they consider only whether the applicant's name is similar to another party's name. That is a very limited inquiry and doesn't come nearly as close, and doesn't therefore ventilate the trademark infringement and passing off issues which we bring before this court. Also, my lord, neither the IEC nor the Electoral Court can grant the interdictory relief that we seek in this application. All it can do is deregister a party or refuse to register a party. It cannot stop that party using the trademark. So, for example, my lord, if the organisation, let's hypothesize that the IEC or Electoral Court had in fact said that Mkhonto Sizwe was not allowed to be registered because its name was inappropriate on some basis, that would not stop them using the name in public. They could carry on calling themselves Mkhonto Sizwe as an organisation. That's where trademark infringement is much broader than anything that the IEC or the Electoral Court can do. It is to stop the use of the name entirely that a person brings a trademark infringement or passing off claim. The IEC and the Electoral Court can't grant that. So, my lord, it is we disagree strongly, my lord, with your lordship's finding that the Electoral Court was the appropriate forum. It could never have granted the relief that the ANC seeks in this matter, and the fact that it was raised in that forum is not, has no bearing on whether your lordship has jurisdiction. And finally, once your lordship found you had jurisdiction, it ought, with respect, to have exercised it. And we say, therefore, there are strong grounds, or good reason to believe that an appeal court will differ with your lordship's finding insofar as jurisdiction is concerned.
Mr. Mayor, just going back to the notice of motion.
Yes.
1.2 was for relief that the first respondent, Mkhonto Sizwe Party, is interdicted from using the logo.
Yes.
The warrior and the shield logo. Then 1.3 is the name, the use of the name.
Indeed, my lord.
So, in essence, what you contended for is that not only should it change its name, but also change its logo.
Indeed.
And you'll recall that at the time when the matter was argued, I inquired from you practically what effect that would have, and you said, well, it would mean taking down all of their banners and election paraphernalia in total, because you couldn't have one without the other.
Indeed.
Okay. And that's still what you asked for.
Indeed. Well, of course, they've taken the banners down now anyway.
Yes.
But yes, we will ask, we would seek an order.
So it's literally an order expunging their name.
Indeed. preventing them from using their name, yes. From preventing them from using the name Mkhonto Sizwe, we would require them to change the name and the logo. It happens, my lord. Political parties do change their name.
I don't think by court order, though, Mr. Mary.
Well, it's no different to a trader being told that they have to change their name. And just while we're on the notice of motion, my lord, again, just on back to this jurisdiction point, none of the relief that we seek, 1.2, 1.3, 1.4, 1.5 damages could be granted. My lord, on the question of locus standi,
Yes.
we submit that your lordship erred with respect in finding that there had been a vesting of rights. We also disagree with respect that Section 19 of the Constitution was invoked, because nothing about the relief that prevents the first respondent from forming a political party, participating in the activities of a political party, recruiting members, or campaigning for a political party or cause. Section 19, as we've said in the application, does not guarantee the right of every citizen to form a political party having a name that infringes upon the rights of others, and nor does it guarantee the right to campaign under such a name. And the point we make simply is change the name and you can exercise your Section 19 rights at will. So we disagree with respect, again, that the Section 19 was invoked. We also disagree that a registration at the IEC renders a political party immune to trademark infringement and passing off cases. I mean, consider, for example, my lord, or hypothesize that this trademark had never been assigned from legacy projects to the ANC. Legacy projects has no locus in the electoral court. It would have to be
In the High Court.
in the High Court. So it cannot be so that the registration of at the IEC renders one immune or vests rights in a political party which overshadow or trample upon those of trademark rights. And it also is with respect, there's no basis to say that the rights of a political party that owns a trademark are any different to those of an ordinary person on the street. The point we make is on the locus standi is this. When the MK Party was registered as a political party in September last year, there was no vesting of rights that happened for two reasons. One is because that registration does not render the political party immune to trademark infringement proceedings, as I've said. And the second is that at the time they were registered, your lordship focused on the trademark assignment, the fact that it had come after the registration. But at the time that they were registered, of course, legacy projects owned that trademark.
Yes.
And those rights were not extinguished by the registration of the MK Party, and the goodwill for the passing off claim vested in the ANC. And so there can be no...
But the vesting of those rights with legacy prior to the assignment to the ANC.
Yes, my lord.
What is the effect of that?
Well, the point I'm making, my lord, is that you cannot acquire rights, as the first respondent contends it did when it got registered, which when the very acquisition of those rights tramples upon and extinguishes the pre-existing rights of others. So how can it be that because they got registration, they are now no longer infringing legacy projects' rights.
Yes, but legacy projects didn't enter the fray to oppose
Well, but
legacy projects at the time didn't institute any action in the High Court to protect its right.
of course not. No, but its
Yes.
rights were not extinguished. It can't be. I mean, my lord, the mere fact that a political party is registered.
But you said that the infringement occurred at the time of the registration.
Well, indeed, my lord, it started
Yes.
then.
And the infringement being vis-a-vis the MK Party and Legacy at the time
At
of
that
registration.
Yes, it would have been infringement. The point, my lord, is that one cannot acquire rights which contravene the rights of others. In other words, which are in conflict with pre-existing rights of others. And it was in conflict with pre-existing rights of others. It was in conflict with the pre-existing rights in the trademark, which at that time registered in the name of Legacy, and it was in conflict with the ANC's rights of goodwill, which vested in the name. And just to round off and going back to the first point, the effect of your findings, my lord, is effectively that those rights, trademark rights and the common law rights, were extinguished by the registration of the IEC. In this respect, we say that is a finding which is likely to be, which another court may well come to a different conclusion. Those are the preliminary issues. And so far as the trademark issues proper are concerned, my lord, under the case under section 34(1)(a), your lordship found that the green background was sufficiently distinctive. My lord, as we pointed out, that is not always used, and in any event, it's not sufficient to distinguish the two marks because the ANC uses green too. And as I've said before your lordship at the previous hearing, it's not limited to use in any particular colour, the trademark registration, and for that reason as well, that finding with respect we say was incorrect. On the question of whether the services are similar, again, my lord, we submit there's a reasonable prospect that another court will differ with respect to your views as to the scope of Clause 41. That is, again, a novel issue, not one that has been considered by our courts before. The political, the extent to which political activities such as campaigning, conferences and the like fall within the scope of Clause 41 is something that another court may reach a different conclusion to that of your lordships. Then, my lord, insofar as on the question of confusion, your lordship will recall, and we had this debate in the last round as to where confusion takes place. And your lordship has had a particular focus in the judgment on the ballot box. But as I explained, lordship and we maintain is the position. Confusion takes place not only at the ballot box. Campaigning is a process of education. If you are educated through the campaigning of it is an association between one mark and another. It doesn't matter how similar those marks are. So it doesn't matter that when they get into the box they see ANC and MK. If they have been taught through campaigning and through the use of logos and through the use of trademarks that there is a link between those two marks, then confusion will arise. And it is precisely that. That is why they have adopted these marks. These are not marks that they plucked out of the air, my lord. These are very well-known marks in this country. They are indelibly associated with the ANC. The point was to create the association with the ANC. The point was that the MK party will always be known as being in the same house as the ANC. And they chose these marks because that conveyed that message. So, my lord, the fact that they then get into that a voter gets into the voting box or voting booth and sees the ANC and the MK is, by then, it's far too late. The confusion has already been sown because the link has already been created between those marks. And it is the use prior to the voting box on the campaign trail that gives rise to the confusion and deception. And it will continue from now on in every parliamentary session, in every conference, at every by-election. That association will continue.
Mr. Marriott, that point is made right at the outset in your application for leave to appeal. Have I mischaracterized the applicant's case, or as I look at it, my framing of the applicant's case appears to be taken directly from the applicant's founding affidavit? I just want to get some clarity.
Sorry, my lord. I think where it's taken, I'm not sure which paragraph your lordship is referring
21,
to. Sorry.
page 13 of the founding affidavit.
21.
Yes.
So, my lord, this is under. So this is where I started my submissions today. It's under the heading of urgency. Now, it is. I need to be understood. It is a part of our case, and it was a part of our case, and it was used to justify urgency that there would be confusion in the lead-up and during the 2024 elections. That was a part of our case. And it was used as the basis upon which to justify urgency. But as I've explained, my lord, when we deal with the conduct, the actual infringing conduct, and when you look at the notice of motion, which one can start from page 40 of the affidavit all the way through to page 51. This case is about a continuing wrong, ongoing use in all contexts of the eNCA system. Just logically, my lord, it would make no sense for the ANC to say, well, I object to your use of the eNCA marks before the election, but after that it's absolutely fine. And they never said that, my lord. From page 40, your lordship will see that the case was about the ongoing use of marks in all contexts. And then finally, on the question of confusion, we submit respectfully that the finding that the MK Party would seek to disassociate itself is not one that was supported by the evidence. We quoted in the affidavit statements by the leaders of the MK Party in which they actively sought to associate themselves with the MK, calling themselves one of the rooms within the ANC. Now, that is an association. And it is always the case in trademarks, infringements and passing off cases that the alleged infringer seeks to associate themselves because there are obvious and logical benefits to doing so. Then, insofar as section 34(1)(c) is concerned, in respect, we do contend that that is the section of the Act which doesn't require confusion or deception. It requires only that the marks be similar, that they be well known, and that they take unfair advantage of the well-known marks. And for the reasons...
Sorry, that's under...
34(1)(c). we've dealt in our heads of argument in paragraph 6 and 7. With this point, my lord, to say that the court ought to have found, with respect, that by adopting a similar mark, which is all the section requires, it's similarity and confusing similarity are different concepts. The MK Party sought to do precisely that which the SCA found to be objectionable in Cape Cookies. In other words, they took unfair advantage of the power of attraction, the prestige, and the repute of the Encontro Caesar mark. And we all know that power of attraction had been built up over a considerable period of time, with a considerable investment of, not money in this case as much, well, there is some money certainly, but in terms of the struggle. And and what Encontro Caesar has done is chosen to adopt that mark as its own. It's effectively taken it, so that it does not have to build up its own legacy. And we submit that is a clear example of taking unfair advantage of a well-known mark. My Lord, those, obviously the passing off, the Lordship found that you were unable to determine who owned the Encontro Caesar mark. We submit respectfully, most of the submissions that are made to you were in fact based on the respondent's evidence. And what is not in dispute is that the ANC is at least, and we say we are the sole, but at least a joint proprietor of the goodwill. There may be other organizations like the PAC, but a joint proprietor is entitled to bring a passing off claim. So, my Lord, for all those reasons, we submit that there are good prospects of success on appeal. We would ask for leave to appeal to the Supreme Court of Appeal. We do believe that this matter merits the attention of the Supreme Court of Appeal. There's obviously an enormous public interest in it, and there are novel issues of law. And we would therefore ask that leave be granted to the Supreme Court of Appeal with costs in the appeal.
And that would be a slight change from your application for leave, where you seek leave to the SCA, alternatively to the full court of this division.
The alternative remains, but my primary submission is to the Supreme Court of Appeal.
Yes. Yes, thank you, Mr. Mayor. Yes, Mr. Mpofu.
Thank you, Madam. If I may start before the furniture is rearranged. Thanks. That's good. My Lord, this application for leave to appeal, with the greatest respect. I'm sorry. Okay, thanks. My Lord, this application is dead on arrival. It doesn't get off the starting blocks, my Lord. My learned friend correctly was trying to refrain from re-arguing the case, but he has ended up doing that. And I've listened to him very carefully. At least twice, minimum, he says that there's a reasonable prospect that another court may find differently. Of course, that's not the test. The test is not may. That was the old test. Since 2010, the test has been changed. It has been heightened, quote unquote. And the reason exactly that the legislature saw it fit to intervene and heighten the test was to stop hopeless appeals from passing through to the test. rather to the appeal courts, to stop that floodgate. And this is a typical example of why the legislature did that. Because, my lord, if there ever was a hopeless appeal, this is one. It's impossible, and I use that word advisedly, for this applicant to pass that heightened test in respect of all the hurdles in front of them. The Lordship correctly started with the asking my learned friend regarding the preliminary points. Now, you know, preliminary points sometimes are called technical points. But here we know that the preliminary points actually have an impact on the merits, a serious impact at that. Because let's just take an example. If the ANC does not have the locus standi to bring this matter, let's just say that for a minute, then at the very same time, it cannot be the enforcer of the trademark infringement. Let's assume there is a trademark infringement. But if that trademark infringement is not available in the hands of the ANC, then that's the end of it. So that's a matter that cuts across the so-called points in limine, but it also goes into Section 34 itself. Now, let's start right at the beginning. Why this is not appealable. My lord, your lordship did the correct thing of finding that the matter was not urgent. Your lordship could have ended there, by the way. Could have just said, the matter is not urgent, goodbye. But your lordship, because of the importance of the matter, because there might have been further proceedings and so on, did what the SCA has always said must be done. That a court, even if it finds against the applicant on preliminary points, must nevertheless deal with the merits, because otherwise it prevents the court of, it's called the Spielhaus rule. It prevents the SCA or any other court from having to deal with the matter as a court of first instance. So that's just a matter of judicial prudence, if you like. But it should not be abused to deny the fact that your lordship was quite entitled simply to say this matter is not urgent, and that's the end of it. Now, had your lordship done that, which your lordship was entitled to do, the matter would not be appealable. So it can't now graduate to becoming appealable simply because your lordship also dealt with the merits obiter, so to speak, for what I call for reasons of judicial prudence. So that's the first issue, my lord. And your lordship did not just say the matter is not urgent in a one-liner. Actually, your lordship went to great lengths to explain why the ANC, for months and months on end, did nothing to prosecute its so-called trademark infringement, and only did so after the December 16 announcement by former President Zuma. Your lordship goes into that. I don't need to go to traverse that road. And we know, my lord, and the reason why your lordship went into that history, we know why they waited. It's because they were pursuing, rightly so, in the Electoral Commission, and they appealed, and they lost that appeal, and so on and so on. But all that could not have prevented them in September or whenever they became aware of the infringement. Or let's even say after the day after the assignment. Remember, the assignment was done exactly so that they can acquire the rights, as my learned friend says. Then you acquire the rights in September, and you do nothing until January of the following year. And as if that is not enough, then they say that so we say the agency is self-created, which is one issue. The second issue, which really comes to the nub of what we are about today, is why then would they not have received relief in due course? So what do they say to that, my lord? They say, no, we could not get relief in due course because there are elections on the 29th of May. Fair enough. But now the case changes. So today we're told, no, we could get relief in due course because this matter goes on forever. You know, there are by-elections, the 2029, 2034, whatever, there'll still be the so-called continuing wrong. So the case cannot change according to, you know, the weather. It must stay what it is, and that is why, my lord, and this takes us to the issue of jurisdiction. Lordship will forgive me if I'm jumping from one of these so-called preliminary points to the other, because they're related. That's why, my lord, the basic law of this country, in Taba, in Chirwa, all the cases that your lordship referred to, is that paragraph 75 of the Taba case says that you determine jurisdiction according to the pleadings. So you can't now plead the case from the bar, you know, according to what stage of the electoral process we're in. That golden rule that says you determine the matter from the pleadings is the death of this application. Because your lordship asked a very pertinent question. Mr. Marriott, where in your papers do you talk about by-elections of the future and so on and so on? Nowhere. So that's something we hear of today. I'm inviting my learned friend to answer that question when he replies. Where in these papers, not in, you know, we know that there'll be other elections and so on. In these papers, where do they deal with this new case of the future? And I'll tell you, my lord, what they actually do. They deal with the present, as in May 29. And then they even deal with the past, but they don't deal with the future. The present, they deal with paragraph 21 and 22. Your lordship has already referred my learned friend. Now, 21 and 22 completely stops the debate, because they say there is overwhelming public interest in ensuring that when the voters approach the voting booth, it's page 13. They are not confused as to the party which they are placing their trust in. It is a matter of clear public interest that any voter confusion, underline those words. So they have decided. Of course, we know that the law talks about confusion. They voluntarily decide to specify which confusion they are talking about. It's not the confusion of soccer spectators or whatever. It's the confusion of voters. So they are bound by that self-confined definition. And they say it's important that is clarified by your lordship before the elections takes place. Before the elections takes place. And then given that we're in electoral, it is for that reason that at 22 now, that the ANC requests that this court must attend to this matter urgently and expeditiously. Now, I say this, my lord, and in fairness to my learned friend, they did allude the last sentence of 21. So it is therefore to the benefit of all parties that the matter be clarified before the general elections, as the next general election will only be held in 5 years. So that's the only allusion, if you like. But they say it is for that reason that the ANC requests that this court must attend to this matter urgently. Now, we make this point in our heads, my lord. A case cannot be based on a particular election and voter confusion and all those things for the purposes of urgency. But for the purposes of the merits, it's something else. Because that urgency, there's no such thing as, it's like trying to unscramble the egg. It's an urgent application, it's one thing. Your Lordship dismissed the urgent application of the ANC. And that urgent application was premised on the May 29 elections. To make matters worse, my lord, if you go to right to the end, that's paragraph 50. My learned friend referred you to 62, I'm sorry. It's 50 of the... No. No, it's paragraph, I'm sorry, did I say paragraph 50? Page 50, man. Paragraph 107, I'm sorry. The Lordship was referred to these paragraphs by my learned friend. But look what they say at 107. In fact, the first respondent has made various attempts to create a non-existent link between the ANC and itself. The applicant has clear right in the form of its registered trademarks as well as common law rights to the name Umkhonto weSizwe. The first respondent has infringed these rights. In other words, they have infringed the rights in the past, according to them. That's why I say they cover the past and then they cover the pre-29 May period. But nowhere, as your Lordship pointed out, and as I've asked my learned friend to do they allude to the future. Now, that then also finalizes the issue of jurisdiction in the following way, my lord. My learned friend is correct, of course, that the High Court generally has the right to deal with trademarks, that nobody is going to argue against that. But that's not what we're debating here. It is like, my lord, if you say, I'm bringing a labor matter here, and then I say, no, but the High Court has jurisdiction to deal with contracts. So I'm based, of course the High Court has jurisdiction to deal with contracts, as the High Court has jurisdiction to deal with trademark infringement. But if my pleadings show that actually what I'm complaining about is an unfair labor practice, then I must go to the labor court. That is, by the way, the reason why specialist courts are created. It is effectively, if you like, to eat away from the jurisdiction, the inherent jurisdiction of the High Court.
Yes, but the point which is made by Mr. Marriott is that the applicant would not have been able to get in the electoral court the relief that is sought in the notice of motion. That's, if I understand his argument correctly.
Yes, it is, my lord. But that's not correct, my lord. Remember the history of this matter. They are the ones who decided to split the baby, so to speak. It's not even a secret. Like literally on the same day, the 9th of January, they decided to issue two matters. One in the electoral court, one in this court. Literally on the same day. Both affidavits signed by Mr. Mbalula on the same day. Now, that might have been for tactical reasons or whatever, but it has backfired because both courts, in a way, found that they don't have jurisdiction. It looks like they should have swapped the matters around. But be that as it may, my lord, the issue, and your lordship did ask this question, I can't remember how your lordship framed it, was when you are splitting these matters, as you are doing now, which one becomes which? Because, and I'll tell you, my lord, why part of that strategy was clever lawyering, so to speak. They understood that to come here for the trademark infringement, one of the issues is going to be unauthorized use. Now, this actually is a shortcut to this whole case. So they thought, okay, let's first do the deregistration, and then the deregistration will then deprive us of the defense that the use is authorized. Unfortunately, they failed because the deregistration case was dismissed before we came before your lordship, I think a few days before we came to your lordship. Now, once you do that, my lord, then how can you get an order in this court for whatever relief you seek, but which is hinged on where the element of unauthorized use is an essential element?
So, assuming that the deregistration case went in favor of the ANC, would the ANC's case before this court have been on a much stronger footing?
Absolutely, absolutely, my lord. Because remember, I call it the overlapping element. Because remember, unauthorized use is required for both Section 34.1a and for 34.1c. So I could not have then come before your lordship and say, well, the use is authorized. Because your lordship would have said, well, to the extent that it was authorized in September, it has now just been unauthorized by the electoral court. But once they lost that case, my lord, they cannot with a straight face come before your lordship and say that the use of the logo and the mark and the name and all those things is unauthorized, because it has just been authorized yesterday by the law, by a court of law of 5 judges. So it matters not. Of course, Mr. Marriott is right that if you like, the pure trademarks case could not have been decided in the electoral court. But you can't purify. You're the one who scrambled the egg. You can't then now want to unscramble it, because, my lord, it's not. They blame your lordship for as it were, not distilling the pure trademarks case. Again, my lord, they must not blame your lordship, they must blame Mr. Mbalula. At page 48 of bundle B, your lordship will remember it's FA6.
Are you talking about the electoral court?
Yes, those papers, my lord.
Yeah. 46, you said.
48, my lord.
Yes.
It is the ANC, not your lordship, that makes the linkage. Remember, at this stage, there's no High Court application, my lord. This is a letter that he's writing to the chairperson of the IEC. The date your lordship will find at page 50, 20th September 2023. 4 months before they come before your lordship.
Yes.
And he says, the last sentence, therefore, any political party registered under this name and the symbol that is inextricably linked to it will, by necessary implication, deceive or confuse voters as contemplated in section 16(1)(b) of the Act. What Act is he talking about? The Electoral Commissions Act. So they link their complaint to this, but here's the highlight on the next page, page 49. The distinguishing mark or symbol from Mkhonto we Sizwe Party as it appears in Annexure B has been registered in terms of section 29(2) of the Trademarks Act with effect from 20th August 2014 for a period of 10 years, and so on. If you just go right down, my lord, as such, yeah. As such, the registration of Mkhonto we Sizwe as a political party using this symbol and the name that is inextricably associated with it would be in violation of these intellectual property rights. The word "these" there refers to legacy projects. So he says it was registered by legacy projects for 10 years and so on, and it would be in violation of these intellectual property rights. So it's not your lordship, it's not MK Party who introduces the symbiosis between the Electoral Act and the trademarks violation. That's how the case is pleaded by them. And that is why, my lord, we advisedly included the papers of the Electoral Court in front of your lordship, at the risk of overburdening the record, because we did not want this party to do one thing in one court in Bloemfontein and then do another thing in the court in Durban, hoping that this court doesn't get sight of what is happening in the other court, which is really what they were trying to do.
Yeah.
So my lord, as I say, I'm sorry to repeat this example. It's the same example, my lord. So if I went to the High Court with a labor matter, I can't then say to the High Court, okay, well, I know it's a labor matter, but what I'm asking for you is an interdict, and you have jurisdiction. Simply, it now stops being a labor matter, because an interdict in a labor matter, as I say, it's the same thing. So you really can't separate it. So those are the preliminary issues, my lord, of agency, the impact of the agency issue, the issue of jurisdiction. When it comes to locus standi, my lord, that's the killer. There is no way out. How do you come out of the reality, my lord, considered by them, that as at the time of the registration, which is the 7th of September, the rights, such as they were, did not belong to the ANC. Assuming the assignment is valid for the purposes of this discussion, that assignment on their own version kicks in on the 23rd of September. And the issue of locus standi, my lord, it cannot be separated from the other issue we raised of non-joinder. I know that your lordship didn't deal with it specifically, but that's because we said that to your lordship. We said those two issues are intertwined. But the importance of why they're intertwined is this, my lord. You can't do what my learned friend is trying to do now. You have to make a choice. You either say, yes, those rights belong to Legacy Project, at least for that 2-week period, and then the ANC bought them, as it were, after the assignment. If you concede that, as my learned friend does this morning, then why did you not join Legacy Project? Because clearly, at least for part of the infringement portion, they were the holders of the right. And if my learned friend is correct, he says his last submission was, at the very least, they were joint proprietor. Well, we know the law, that if they are joint owners of any property, corporeal or incorporeal, then both of them have to be part of the case. So that's what my learned friend is tying himself into knots that are inextricable because you solve one problem and the other problem arises. By conceding that legacy project was the owner, then that means that they are conceding the non-joinder point, if they are joint owners as they now describe themselves. But there's something even more fundamental, my lord, in this. The ANC, and I don't understand this because I think Mr. Mbalula, either it's a slip of the tongue or it doesn't understand the history of the ANC and of MK. We have said, my lord, that we can never deny the fact that there's an association between MK and the ANC. That's not what this case is about. What we say, my lord, is that, now let's go to the so-called pure trademarks law that my learned friend wants us to do. In pure trademarks law, the proprietor must have exclusive ownership. Let's put aside for a minute the issue of joint ownership. But exclusive and distinctive, those are some of the elements. We have said to them, no, forget what we have said. They have considered that the MK Umkhonto weSizwe in 1961 was formed by what they call the congresses, right? We explained that in our answering affidavit. What are the congresses? The congresses meant the ANC, the South African Indian Congress, the Congress of Democrats, and SACTU. And the SACP was not part of the Congress Alliance. But
Mr. Mpofu, I'm sorry to interrupt.
Yes,
obviously don't want you to re-argue the case.
Yes,
I've
yes,
already
of course.
found in your favor.
Okay, madam.
Yes.
Yes.
I think
No,
let's just stick to the grounds of appeal.
Yes, yes. Now, okay, my lord, what I'm saying is this. You can't really argue the case in this kind of compartments that my learned friend wants you to. If they concede, as they do here, that the Umkhonto weSizwe was formed by other people, I forget who they were, then the implication of that is that it cannot be a badge of origin. Because remember, that's what trademark law is about. You are protecting what you call the badge of origin. You are the inventor, in a way, of something. And I think the point I've already made. So they should have either joined the SACP. At least is the only one surviving party of what they call the founders of Umkhonto weSizwe. They even say that.
But Mr. Mpofu, my decision doesn't deal with the issue of non-joinder as a stumbling block for the applicant.
Yes, no, I accept that, my lord. But I'm saying the reason why I'm the one who invited your lordship not to, because I said it's intertwined with locus standi. So that's why I'm dealing with it as part of the locus standi. But be that as it may, my lord, my submission is this: they cannot go past any of the preliminary points, and even if they could, they can't go past the appealability point. And then the third point is that the matter is moot on these pleadings. It's now moot because the elections have come, they've gone. People are all over in legislatures and in Cape Town and everywhere. So on these papers, the matter is moot. And your lordship knows that our appeal courts are very sensitive to this question of having an appeal that is brought there just for academic purposes or to satisfy somebody's ego and so on, where there is no live dispute, really, on the papers before them.
What of Mr. Marriott's contention that if they are denied the opportunity to appeal the matter, their goodwill in the name continues, and I use his words, to be eroded into the future? What what is available
Yes.
in the hands of the ANC to prevent that if
Yes.
that has taken
Thank
place?
you, my lord. The answer to that is very, very simple. It goes back to the golden rule. You are bound by your pleadings. If the ANC feels that its so-called goodwill is being eroded going into the future, they must bring an application to court. It's very simple. You can't, my learned friend accuses MK Party of wanting to hang onto the coattails of the ANC. Well, they want this case to hang, or the infringement case which they should bring now, to hang onto the coattails of this case. You can't do that. An appeal is not a place where you want to now assert new rights. If they want to assert new rights, they must bring another application. That's the recourse, my lord. Bring a fresh application. If we say in that application, no, it's res judicata, they can say, no, no, no. That case was confined to the period up to the 29th of May. Now, you are doing by-elections here and by-elections there, what have you. So the answer is very simple. If they feel aggrieved like any other litigant, they must litigate. We're here, we're ready for them. So that's the answer to that. And so that's the end of the preliminary point. Now, coming to the merits, my lord, I'm going to be very short, because really the shortcut is this. I'm going to only deal with two elements. Unauthorized use we've already dealt with. The second one is in the course of trade. And the reason why I'm dealing with only those two is because those are the two that overlap between section 34.1a and 34.1c. So if they fail in those two, then we kill two birds with one stone, as it were. So I want to address unauthorized use again. In the course of trade. My lord, your lordship will remember this. I remember it as if it was yesterday. We said, okay, now show us, assume everything, the assignment is correct, you are the registered proprietor, and so on. Which class? And they said class 41. And the lordship said, well, one that covered the what we are busy with here, and we had all agreed to frame it as electoral politics, as it were. And my learned friend said, no, it's there on the list. And he took the list, he looked, it was not there. And it's still not there today. And it will not be there next week. So if the element of in the course of trade cannot be met, could not be met, then, and my learned friend was at pains, or rather constrained to concede that, even if not in so many words, then how is that going to be suddenly cured in the SCA? At what point is it now going to be class 41? And again, your lordship dealt extensively with this in the judgment, to say that I think the last attempt was to say, well, it deals with congresses, the class, and therefore a political party also holds congresses. I don't even know what that means. But it was an ill-fated attempt nevertheless. And the point I'm making, my lord, is simply this. Remember, we're in the application for leave to appeal. So in which world can we say there's a reasonable possibility that another court would find that class 41 applies? It will never happen. I can put it that strongly. It will never happen. So why burden the higher courts with something that is stillborn and completely dead on arrival at best? So I'll leave the 34.1a and 34.1c. Now let's go to the last point, which is passing off. The passing off matter, my lord, is the one that your lordship, with the greatest respect, dealt with right from the beginning. When your lordship said to us, please parties, can you give me the two logos of what will be in the ballot box? That was the end of the passing off case. Because the issue of similarity or dissimilarity, the so-called what's it called, side-by-side analysis, completely deals with that, because you can't pass off a paragraph 65 of the judgment. Your Lordship put the two logos literally side by side. Your Lordship will find that at 65 of your Lordship's judgment, page 34 of the typed version, where your Lordship has put umkhonto wesizwe logo as it will appear in the ballot box, in the ballot paper, sorry, and the ANC logo. So the issue of so-called voter confusion as it relates to the passing off is completely destroyed by the so-called side-by-side analysis. But let's put aside the issue of similarity or dissimilarity and go to the goodwill that was mentioned now. Now, I ask this, my Lord, as a rhetorical question. If the goodwill in the MK logo resided with the ANC all along, then why did they go and buy it from legacy projects? The act of buying, because that's what assignment is, just a big word, but they want to buy the goodwill from legacy projects. Now that poses two serious stumbling blocks for them. One is you can't then come here to protect that which you did not have and bought later. Obviously, if it's a house, you can't say, well, I've come to buy the house, but I'm protecting it retrospectively. Your Lordship dealt with that. The quintessential law of trademarks is that a trademark cannot be retrospectively assigned. Then the goodwill argument is just fallacious. We know that it's admitted that they disbanded umkhonto wesizwe in 1993, and then they allowed, quote unquote, legacy projects for 9 years to appropriate exclusively the goodwill. So if indeed this was a so-called pure trademarks matter, why did they allow legacy projects to go for 9 years with their exclusive mark or logo? It is because it had been abandoned by them deliberately, and that process cannot be, you can't erase that history, my Lord. Yeah. So whether you look at it from the point of view of similarity, there's no passing off. And whether I look at it from the point of view of reputation stroke goodwill, there's no passing off. And so that's the end of the case. The very last point, my Lord, is that in any event, the nature of the relief sought before your Lordship is interdictory. And therefore, the harm which they have identified is confined to the pre-election period. You can't now come in and want to expand it later in the SCA or any other court. It would be a tragedy, my Lord, if we were to overburden any other court with this matter. When the horses are loaded, they left the station, and I've run out of metaphors to describe the situation that we're in. So it really would just be for pure academic purposes to say, oh well, wouldn't it be nice if, what would happen if a political, courts are not for that. That will be left to academics The academics will analyze your lordship's judgment and say what they have to say, but not to waste our scarce judicial resources on this, as the court pleases me.
Yes, thank you, Mr. Impofu. Mr. Marriott?
My Lord, I won't be long. On the question of urgency, my Lord, I don't think I need to address you. Your Lordship gave an order, and that order is appealable. Your Lordship dealt with the merits. As to the mootness, my learned friend challenged me to say where the ongoing harm, continuing harm, was pleaded. I did that in my opening address, my Lord. From page 40 onwards, we don't refer to the election, and he didn't deal with that at all. And I would invite your Lordship, just specifically within that paragraph, to have a look at paragraph 100, within that section, should I say, to have a look at paragraph 108 on page 50. It says, my learned friend took you to 107. It's where the point is made about the creating of a non-existent link, and then it says the longer the conduct of the first respondent continues, the greater the likelihood of loss and damage to the ANC. There's no adequate remedy to prevent the first respondent's ongoing unlawful conduct other than an interdict. That's not limited in time to it suddenly stops, you know, when the May 2024 election happens. And on that point, and of course then he goes to paragraphs 21 and 22, which again we have explained, relate to why an urgent hearing was required. Everything we said, everything that was said in that context, we stand by with respect, because there was irreparable harm in the elections. But the fact that there was irreparable harm doesn't mean that the infliction of the harm should be allowed to continue. So, my Lord, and then my learned friend used many metaphors, and he ran out of them, to say that it was that it was academic, my Lord, but they're still using the mark.
Mr. Mayor, let me raise one issue with you.
Yes.
Mr. Impofu says, well, if the case that you've brought is considered by at least this court to be confined to the 2024 election. I know you take a different view, obviously, and that's where we part ways. If you wish to rein in the erosion of the mark, of the goodwill that resides in the ANC through the name and the logo, your options are to institute a fresh action, and it would not be a defense of res judicata because of the court's finding that this was confined, this case was confined to the May 2024 elections, and therefore any subsequent case is not shackled by that. What's your...
No, with respect, it would be res judicata. Your Lordship, whether it's time bound or otherwise,
Yeah.
the substance of what your Lordship has found is that these marks are not confusingly similar. Your Lordship has found that there's no unauthorized, that the use is authorized. Your Lordship has found that under section 34(1)(c) that there's no unfair taking advantage of. The causes of action have been decided. We can't come again. Otherwise, my Lord, it would be open to every infringer in a trademark case to say, well, oh no, but that was last year. I'm still using the same mark, by the way, this year, but that was about last year. It's nonsense, my Lord, with respect. It's really nonsense. So, my Lord, there's no time bounding of trademark cases. Similarly, my Lord, there was no splitting of matters between the electoral court and this court. There was different relief sought on different causes of action. And the deregistration case had no bearing on this case because it dealt with a different issue under a different act. And it would not have stopped Mkhonto Sizwe using the trademark. Nothing about that process would have stopped them using Mkhonto Sizwe. My learned friend, you put the proposition to my learned friend, well, it may have made our case stronger in this case. Well, even if that was so, it doesn't mean that we are debarred from getting relief that we seek from this court. It may help us to get the relief. On the question of jurisdiction, my lord, I explained in my first address that the fact that the ANC raised the trademark in those proceedings does not deprive you of jurisdiction. And as I understood my learned friend, he conceded that the electoral court would not decide the trademark issues. That's the end of that debate. On locus standi, my learned friend calls it a killer point. With respect, I beg to differ. He contemplates the joinder of legacy, which is not an issue that you even considered, my lord, and it is never required that one joins past proprietors of trademarks in trademark infringement cases. The current proprietor is entitled as a matter of law under the Act to an interdict and damages, and the ANC is the sole owner of the trademark. He conflates in this regard what I said about the passing off and the joint ownership of goodwill and the common law rights with what I said about the trademark. The trademark is exclusively owned by the ANC, and it alone is entitled to bring trademark infringement proceedings. Then, so my lord, the preliminary points ought to be no bar to the grant of leave to appeal. As regards the merits, my lord, my learned friend dealt relatively briefly with those issues. He said he dealt first with authorization, albeit that he dealt with it earlier. But my lord, it is, again, it's not something I have dealt with, but your lordship found that this use was authorized by the IEC. It's the same point as the vesting of the rights point. It's not something that the IEC can authorize. As regards his other submission about in the course of trade, actually what he was referring to was the similarity or otherwise of the services, which again I have dealt with in my opening address. He inaccurately says that the services that we relied on were not there. The correct position is that indeed some of the services were included in the NIS classification, and we maintain that a different court may come to a different conclusion as regards the similarity of those services. Finally, my lord, on the question of passing off, my learned friend says glibly that, when you have a joint owners of property, you both have to be joined. Well, that's not the law in relation to trademarks. If I own the goodwill and somebody else owns a goodwill, we've given you the authorities in your heads that a joint owner of a goodwill may institute proceedings in its own name. So there doesn't appear to be any material dispute that the ANC is at least a joint owner. In fact, my lord, on this question of whether the ANC has established the goodwill, one need only look in the answering affidavit of the Mkhonto Sizwe Party, page 121, paragraph 19.16. It says, the narrative of the ANC also fails to make the crucial distinction between a trademark and a brand. And I must say, I'm still waiting to learn what that distinction is, but the ANC may well have been associated with Mkhonto Sizwe. That's its affidavit. And it follows on a long discussion about how the ANC was integrally involved, at the very least, throughout the history of the Mkhonto Sizwe. It is at least a joint owner of goodwill, and a joint owner is entitled to bring proceedings in its own name. And then finally, on the question of the test, I've made my submissions regarding the comparison of the two marks in the ballot box. And I've explained that for passing off, that ignores the evidence which shows that the association that is indeed sought to be drawn, including by the leaders of the MK Party, But it's also the wrong test, and I just go back to this, the wrong test for trademark law. Trademark law requires a comparison only of the registered mark against that used by the proprietor, and the registered mark is the mark that is on the register of trademark, not that which is registered before the IEC. My Lord, we have been in healthy debate for 90 minutes.
Yes, thank you.
If ever there was an indication of perhaps leave to appeal ought to be granted, we submit that there are indeed some issues that warrant further attention.
We'll have to wait a little bit longer. I intend to reflect on the arguments, and I'll hand down a decision in due course. Parties will be advised in due course. Yes. Yes. Judgments reserved in that. Thank you. All right.
Are you still? Even